to Graeys Cast. On today's episode, we are going to be featuring the sports department of the firm. And we have the partner in charge of the sports department in person of Mr. Steve Nwabueze. Thank you, sir, for joining us today. Good evening. So we're going to be interrogating the decision of the court in Claudia Pechstein and International Skating Union, ISU. So in a situation where an athlete is not comfortable with the name on that closed list, that's the arbitrators on court. For instance, most blacks will have problem having a white person as an arbitrator, especially when the person on the other side is a white person. So we prefer a black lawyer as our arbitrator. So in that instance, can that athlete go outside the list to appoint another arbitrator?
Unfortunately, as I mentioned from the outset, your scope of choice or your choice is limited to the closed list. So you have to appoint from that closed list. And again, it's not about nationality. If you are raising an objection on the principle of competence in arbitration, the tribunal can determine a jurisdiction on that point once it is promptly raised by one of the parties. That, look, I am not confident as to the impartiality and objectivity of the members of this panel. And then you give particulars of that concern. That will be looked into. Then a considered award on that particular jurisdictional point will be raised. Sorry, will be delivered before the plenary hearing of the substantive matter. So, but unfortunately, as an African, again, you are hamstrung because how many Africans can you possibly or conceivably have in a closed list of castes? Very, very little.
Yeah.
So you are hamstrung by the number of persons that who have their names on that list. So you have to choose from one of them. And again, I don't think that's a valid point of objection. What I was thinking is some kind of affinity, either family affinity,
yes,
or some other primordial considerations that can justifiably question the independence and impartiality of one of the members of the panel.
Okay, that is fair. So the decisions of CAS, that's CAS, is it final? And if yes, so that means you cannot appeal. If no, an appeal from CAS doesn't go to.
Interesting. Again, the CAS is usually referred to as the Supreme Court of Sports Arbitration. Supreme Court in the sense that for a large number of the cases, it is the final bus stop. Then for some other cases, there's a narrow prism within which you can review, I call them judicial review, I don't call it an appeal, review the decision of CAS on the grounds of public policy. So when you are alleging that a particular award, enforcement of a particular award by CAS, it has been issued by CAS, would be against public policy, you can approach the Swiss Federal Tribunal. So the Swiss Federal Tribunal, because the seat of CAS itself is in Switzerland, so it's only the Swiss Federal Tribunal that can sit on appeal over that particular decision. Now, what you have also found out is a number of players, a number of individuals who are members of the EU, who belong to countries within the European Union, now approach the European Court of Justice to go and further review the decision of CAS. And I'll give you an example. Claudia Pechstein. Claudia Pechstein was an ice skater. In 2009, she was found guilty of using a banned substance. And in line with the rules, the ISU, that's the International Skating Union, suspended her for 2 years. So she went to court. Both the decisions of the CAS tribunal that determined her appeal went against her. She went to the Swiss Federal Tribunal, the same story. So what did she do? She proceeded to her local court in Germany because she's a German.
Okay.
So the High Court you have as the equivalent of the Nigerian High Court there in Germany. First of all, the Court of First Instance found out that, yes, that because she was challenging the validity of the arbitration agreement. She said, to the extent that I have not participated in the selection process of the individuals who constitute the members of the cast panel that heard my case, that I shouldn't be bound by them because it violates a very interesting, a very strong principle of arbitration, which is party autonomy. So one of the ingredients of arbitration is party autonomy. To the extent that I have not participated, or my participation has been modulated or regulated by virtue of the institutional red tapes put on my way to ensure that I do not exercise any independent exercise of will in appointing any member of the panel, that the arbitration clause is invalid. The court agreed and said, that the arbitration clause is too general and vague because it has not defined the particular dispute and there are no set down modalities. She wasn't still satisfied because that decision did not overly overturn the award against her. She went to what is equivalent to our own Court of Appeal here, and they agreed with her and said that there's a structural imbalance in the appointment, nomination, and selection process of the members of the cast panel because they are skewed in favor of the sports governing bodies who she was up against. And to that extent, that enforcement of that award was against public policy. But the interesting part, further appeal to the German Federal Supreme Court overturned that decision. So
this was now against Claudia.
Yes, it was against Claudia. So Claudia has not been able to take benefit because he drew a whole lot of reports, from the arbitration community who were excited, especially for sports arbitrators who had taken the view that, this position is a settled view that you cannot challenge the decision of CAS, or you cannot challenge the jurisdiction of CAS.
I'm interested in how she's able to move all the way from CAS to Germany, because you told me that CAS is in Switzerland.
Yes.
So how was she able to successfully appeal to Germany?
Good. So this is another.
And in appealing, she appealed to a court, as you said, equivalent to the High Court.
Yes. So now, her lawyers were very innovative and very creative as well. So what she did was she went outside the narrow ground of challenging the arbitral award on the grounds of public policy. What she did was to go and allege that it violated the competition law of Germany. Okay. Competition law provisions. So essentially, that decision was saying that International Skating Union, ISU, occupied a dominant position. So that dominant position is not necessarily manifested by the fact that they are imposing the arbitration clause on the players, but because of the fact that they have limited the participation of the players in the selection, nomination, and composition process of the panel, such that there's now a structural imbalance that is skewed in favor of the governing bodies like ISU. And to that extent, that they violated their dominant market position. So dominant market position, what the court was just saying was that the ISU was a monopolist. So I have, as an athlete, I have a skill set. My skill set is ice skating. And that is how I earn my living. Now you have developed one set of rules, which I must conform to. I run afoul of those rules, and then you come back to me and say, you are banned, you are prohibited from participating. I can no longer earn my living. So you are a monopolist, because usually these sports governing bodies will not want another parallel body offering the same services. Yes. It's the same challenge that UEFA, Union of European Football Association, was facing with some big clubs in Europe that wanted to float a parallel league known as the Super League. But that's a decision for another day. Now, the European Court of Justice last year now delivered a decision that more or less saying that FIFA and UEFA cannot remain monopolists. That, which means that a parallel body can now come and set up for the same competition.
How many are we going to have?
Well, it depends. It depends on who can pay better. If you can pay like the Saudis, why not? So that is the way it works. So they talking about the composition and independence of the CAS arbitration panel. So the decision in Perchstone has now set the tone for another case that is pending the decision of the European Court of Justice. So yes, so this is another case that was filed some time ago. So it's a case that seeks to challenge FIFA's prohibition of third-party ownership. So FIFA made a regulation, I think in 2015 or thereabouts, prohibiting third-party ownership of players' economic rights. So by the rules and principles, regulations of FIFA, the only person who can own the economic rights of a player is a football club that is contracted to. So it's only that football club that can transfer that economic right to another football club when they receive a consideration, a transfer fee in an agreed sum. That is when they can transfer the signature and the economic rights of that player to the second club. An individual like me and you cannot own the economic rights of a player. So doing sports, there's an agency, this football agency, that facilitated the transfer of a player to a Belgian first division side, RFC Serrain. So they claim that they own some economic rights of the player, and that was what gave rise to this present litigation. They went all the way to CAS and they lost. So they have now appealed to the European Court of Justice. So the European Court of Justice on January 16th, received the opinion of the Belgian Attorney General. Her name is Tamara Capeta. So Tamara Capeta.
Opinion.
So just like you invite your amicus, you invite some senior lawyers to come before the Supreme Court to come and address the court
Like
on yes, exactly. So on some certain principles of law that are not so clear. So now she has now rendered her opinion. So in that opinion, she's advocating that the grounds for challenging the validity and finality, and most importantly, the enforcement of arbitral awards from CAS should be widened. She's no longer
public policy.
Yes, so she's now saying that they should be subjected to more international judicial review. So in other words, that national court
defeats the sole purpose of making it, because from what I understand, the reason why disputes emanating from sports has to go to CAS is so that they can, advocate and give.
There will be harmonization, exactly. There will be uniformity.
Exactly, and within time too. So it doesn't just start prolonging like every other litigation you have. So if we're not giving more grounds, or giving that opening for people to just go to their nation, appeal the matters, will that not defeat the sole purpose of CAS?
Well,
instead of appealing, can we just change the mode of appointment, nomination, and selection of the arbitrators?
For me, from where I'm sitting, I can tell you authoritatively that whatever influence the sports governing bodies have on the appointment of arbitrators on the CAS list is very limited. It's limited in the sense that there's a vetting process that, of course, the ICAS has the final say on who would appear on the CAS closed list. So that list is a well scrutinized list, you can't really fault it, but one cannot close one's eyes to certain international politics that also play out in the determination of some of these issues. I'll give you an example. That is the example of Caster Semenya. Caster Semenya is a South African athlete. She's a long-distance runner. She participated in 200 meters, 400 meters, 800 meters, and 1,500 meters races. So she had her first international breakthrough in 2009. So because of the way she performed, she won the World Athletics Championship then. So because of the way she performed, the IAAF quickly took her in for tests to first of all determine whether she was a man.
Whether she was a man?
Yes, she was a man because of her masculine looks and her baritone voice. So it raised a lot of conversation as to her sexuality. So everybody was interested in, could this be a man masquerading as a woman? So she was subject to a lot of tests. Most importantly, they now discovered that she had unusual high level of testosterone in her body. Testosterone is the brain hormone. So testosterone, by the conclusion or discernment of the members of the IAAF, they claim that it gives her an undue advantage over other female athletes. She was born with this. She was natural. She didn't take any substance. So it became a question of litigation because she was banned from participating in the World Athletics Championship of that year. Because of her nature, yes. So she went to court, went before the Court for Arbitration for Sports. She requested for arbitration in line with the procedural rules. And panel was constituted. I think it was led by Honorable Dr. Hugh Fraser, who was the chairman of the panel, the three-man panel that determined that issue. So one of the challenges she put forward was that regulation, because the DSD, there was a regulation that was put in place. So that regulation was to cut down her participation in the three main events that she participates in. So Caster Semenya, if you follow her closely, she participates in the 400 meters, the 800 meters, and the 1,500 meters. So they now enacted a new regulation, the DSD regulation, which says that because of the high number of testosterone level that she has, or usually high level of testosterone, that she should be taking some oral contraceptives to suppress it, yes. To suppress, I can see the look on your face.
Just so she can participate.
Just so to reduce the testosterone levels. So the minimum, yes, so the maximum level of testosterone allowed is about something. It must not be more than 5 nanomoles per liter of blood in your system. So for you to be able to participate, you must have ingested these oral contraceptives over a period of about 6 months continuously to be able to suppress it. So this particular regulation effectively curtailed her chances of participating that year.
So imagine there will be side effects.
Yeah, so she went to the Court for Arbitration for Sports. She lost, and then she tried to appeal. Imagine you're appealing as an African before the Swiss Federal Tribunal. How do you think that is going to end?
That's what I was thinking about when I said.
So your guess is as good as mine. So it's all about the international politics, but ultimately what they said, interestingly, again, both the Court for Arbitration for Sports and the Swiss Federal Tribunal found as a fact that the DSD regulations were patently discriminatory on the ground of sex.
Extremely.
Yes, because first of all, it applied to only a subset of the female gender, those who have unusually high testosterone levels. And then it is not applicable to male athletes.
It's like someone who is playing basketball and is very tall, and you tell him he can't play because he's too tall. So as a result, he has some undue advantage over others. It is God-given. It's natural.
So where I'm going is that, so I mentioned the Super League case last year that was decided on basis of abuse of dominant market position and breach of competition law principles, which succeeded before the European Court of Justice. I've not given that example. So the FIFA Agents Regulations of 2023 came under serious legal attack from several angles. So a lot of agencies or football agents were filing matters in their national courts, trying to challenge the validity of that regulation. So that the regulation was essentially seeking to put a salary cap on the commission and a football agent can earn from a transaction that is involved in. So they all went. Well, because that is FIFA. So they went to court. There was one case that was filed in the UK. They got an injunction. There was another case that was filed in the Netherlands. They got an injunction in Germany and so many other places. So FIFA had to quickly beat a retreat to suspend the implementation of the regulations.
And nobody has.
But you look at the But you look at the. I'm going somewhere. So, but you look at the dramatic personnel, that's the people who are involved in this litigation. A number of them are members of the European Union. Well, it hasn't been tested in Africa, but I don't know whether we will be able to get the same consideration if we approach a national court in Nigeria.
Yes, and I was going to say, what are the chances that a Nigerian playing in Europe will go to CAS and then successfully come here to appeal the decision of the Court of Arbitral for Sport as Claudia did in Germany?
Well, maybe because our system has not become as sophisticated as the ones abroad. Because a judge before whom you are canvassing arguments on the breach of the competition law principles, we only enacted our own domestic law in 2020. The Federal Competition and Consumer Protection Act is a recent law that has just been passed a couple of years ago. A lot of people are not even yet familiar with the provisions. So maybe it's only a matter of time. Maybe it has not become an issue because the extent of commercialization of sports in Nigeria is still at the base level. So by the time a lot of money will be thrown around, a lot of issues will be at stake, people will be conscious to this part. Because I expected some football agents in Nigeria, we have some FIFA licensed agents in Nigeria. When everybody was making noise, approaching their individual court, I expected some football agents in Nigeria to approach the Federal High Court, for example, to go and enforce this. It would have been a landmark decision because nobody has done that before. I don't know, maybe due to international politics or whatever, we just seem to be at the receiving end as far as Africans are concerned. But that's a story for another day.
One of the things, or regulations that I thought should have been appealed was one that stops Castlevania from participating. Like the particular regulation that said the testosterone had to be reduced, they had to take oral substance to, that is extremely unfair.
Well, the grounds upon which the CAS upheld that decision was on the basis that it was reasonable, it was necessary, and it was pivotal to maintaining sporting integrity. That to the extent that those people who have the unusually high level testosterone can have some form of athletic advantage over their opponents, that they should be allowed a fair chance by suppressing the testosterone.
Why not create a competition for those set of people? So everybody whose testosterone is high, let them run.
Well,
by themselves.
It's an unusual condition. As a matter of fact, between February 19th to February 22nd, 2019, when the CAS was involved in the hearing. It was a hearing that stretched, of course, about 4 to 5 days. So they had to take evidence from gynecologists, evidence from endocrinologists, genetic experts, from pharmacologists, a lot of experts. So a lot of detail went into the evidence. But the ultimate conclusion, we have found as a fact that it was patently discriminatory.
Yes.
So that should have been the end of the story. Because I did not create myself.
Thank you.
So I did not create myself. So asking me to alter myself, there's a scientific explanation for Michael Phelps's very resounding success in swimming. because of his figure. So he has a longer trunk. So he has some other physiological advantages that makes him an excellent swimmer more than anybody in history. So how come? Yes, he was born with this feature. So how come nobody passed any regulations to ask him to suppress his physiological traits?
Definitely the main thing. So I guess the final thing to say would be a summary of what we just discussed. Today we established that matters or disputes from the sports industry with the CAS. When you are dissatisfied, you can appeal to another level of the same CAS. Then that is the final. It's supposed to be the Supreme Court. But because it's in Switzerland, you can also appeal to the Swiss Federal Tribunal.
Yeah.
And after that, that's like the final box stop. But if your country is very advanced, like the European, those countries under the European Union, you can now appeal to a national court, just like Claudia did, where you will also interrogate. But all of this has to happen on the grounds of public policy, you said.
Breach of competition law. So essentially, you are saying that the person is offering the service. Because as an athlete, I have a particular skill set. That is what I use to earn my money. And for me to survive, I have to play in competitions that you organize. So, and because there's no competitor in that industry, I will have to remain subservient to your rules. I violate your rules and I am subjected to your judicial processes. I am not satisfied with it. I am not, I do not believe in the impartiality of the process or the integrity of the process. And I decide to approach the court. I say, court, look, this person is a dominant market position, in the sense that he is the only one, he's operating a monopoly. So because you are the only one offering the kind of services or offering the kind of platform for me to sell or market my services, I am limited. And you are abusing that monopolistic position that you occupy by restricting me somewhat in your judicial process or your arbitral process. So courts, please nullify this arbitral award. It's an argument that can resonate with it. As I mentioned before, there's now a current trend where people just approach, but on grounds of breach of competition law. Yes, absolutely. We had about 3 cases last year where decisions of CAS or FIFA or any of the sport governing bodies have been subjected to scrutiny before the European Court of Justice, and they agreed. So that precedent has been set now. So I expect some very...
We can imply that is now another practice of appeal. Or in another court where you can appeal the decisions of CAS.
Yes, we can. We can, on very limited grounds, though. You have to be a member or a citizen of a member of the European Union. So your country has to be in the European Union before you can do that. Or you have very strong competition law legislation that you can invoke the provisions to challenge it. As I said, we have not reached that level of sophistication in Nigeria, sadly.
Thank you very much, sir, for joining us on today's episode. And thank you to our listeners for staying tuned and listening to us. So now that you've heard everything we discussed about the validity of decisions from the Court of Arbitration for Sports, what do you think? Drop your comments in the comment box and let us know your thoughts on this topic. Anyway, subscribe to our channel, follow us, like our posts, turn on your notification button and stay updated on our channel. Thank you today for watching today's episode on Graeys Cast. Bye for now.